Hello friends, how are you? Myself is Dr. Soni. Regarding prevention of corruption Act, more specifically concerning the offence of Section 7 of PC Act, I am going to explain one of the most important judgment of Honorable Chhattisgarh High Court, which is dated 12th of March 2026. In that case, the accused was convicted and finally he is acquitted by Honorable High Court. So basically, we will understand the strategy, and in case we are going to be implicated in the false case, then what strategy we could adopt to secure our acquittal in that case. So directly we are moving on the board. Today I will discuss the judgment of Honorable Chhattisgarh High Court. Judgment date is 12th of March 2026. Judgment is available on Google. In that case, the accused was convicted as per Section 7, 131D of PC Act. He has submitted an appeal before High Court and finally he succeeded and got acquitted. So basically, we have to understand the strategy and steps adopted by the concerned accused to secure the acquittal. Whenever you are having a case of PC Act, either at the stage of trial or at appeal, we have to follow certain fundamentals. These are called golden rules or principle. First rule is that ascertain the motive on the part of accused as averted by complainant. For example, in that case, the accused submitted that he is innocent, he has not committed any crime. But these averments are not sufficient. First of all, the concerned accused has to observe the motive submitted by complainant against him. In that case, the motive was complainant submitted that he received a notice from department regarding the outstanding in ESI compliances. As per him, no amount is due. Notice is illegal abuse of process. But key point is that he has not challenged the notice. The amount is to be deposited by him. So in that scenario, it is quite clear that he developed animosity in consequence of notice with the consent accused, and that's why he submitted the report. So basically, what the accused has done in that case, he targeted the ill motive on the part of complainant. Because to constitute Section 7 of PC Act offence, it is signed known that demand is on record. Demand must be specific, and prosecution has to follow the guidelines of Honorable Supreme Court judgment, that is Neeraj Datta versus State of NCT. Judgment date is 17th of March 2023. In that case, it is specified that every demand of money, I'm going to specify, every demand of money is not demand of bribe. Prosecution has to specify that accused is a public servant, he is having a public duty, and in consequence of or in anticipation of bribe, he discharged his duties in illegal way or abuse the same to provide the undue benefit to the concerned complainant. If the ingredients are not on the record, in that scenario, the accused could claim the benefit. So basically, the accused submitted that no work is pending, and apart from that, there is an outstanding, and complainant is not willing to deposit the same, and that's why, with ulterior motive, the report is submitted. The said defense appears to be plausible. In the anti-corruption case, usually, in the name of verification, the ACB gives a voice recorder to the concerned complainant. And when the complainant back with the voice recorder, the ACB confirms that in the voice there is a demand, but in actual there is no demand. Sometimes it is seen that mere words are used, but there is no specification of demand, which is sine qua non as per the guidelines of Honorable Supreme Court, which I specified to you. So if demand is not specific, it is general, we could have the benefit. So basically, they have to verify the facts as per section 173, subclause 3 of BNSS. So we have to challenge the process adopted by the concerned SEB so that we could be succeeded in our case. Because usual trend is that do verification, then do pre-trap, followed by a trap proceeding. But each and every time, demand is must. If there is mere recovery, mere acceptance, it is not sufficient. Please be noted. So in that case, the accused had point out certain scenarios. Number one, demand is not proved, sanction is mechanical, and there is no compliance of guidelines of Honorable Supreme Court. Judgment specification is CBI versus Ashok Kumar Agarwal. Judgment date is 31st of October 2013. And apart from that, there is inconsistency in the statement of witnesses. So basically, whenever we are going to observe our case, do review first before proceed. Because we are having three type of witnesses. Number one, complainant plus shadow witness. Number two, hearsay evidence. And number three, sanction. So basically, complainant and shadow witness are the material witness. If there is self inconsistency or there is inconsistency which is going to create a doubt in the case, we could have the benefit. And apart from that, there might be averment of the consent complainant that there is a negotiation in the bribe. If the said fact is not supported with any evidence, then we could have the benefit. And apart from that, we must know that the burden is on the prosecution. The defense is not supposed to prove the defense beyond reasonable doubt. The defense is supposed to stand on the point of probable defense. Please be noted. And apart from that, if no money is recovered from the accused, then it is also the plus point. And apart from that, if the consent shadow witness is not going to support the case of prosecution and it is the averment of shadow witness that he has not heard the conversation, then we could have the benefit. And apart from that, if work is not pending, then we could have the benefit. So basically, we have to emphasize on all these points while arguing our case so that we could effectively put up a strong case for our defense. So basically, we could conclude we have to review our case, then have a defense line, then prepare a question so that we could create a doubt in the case of prosecution. So asking question is your right, but do not ask those questions which are on the vague end or which might implicate you in a trouble. Ask the specific question. If the answer is not specific, then we could have the benefit. For example, Mr. A says that Mr. B demanded rupees 10 lakh for work. But the key point is that work is not pending with Mr. B or he is not competent for the work, then it is the case of probabilizing defense. So based on probable defense, the presumption could be repeated. So everything is to be proved by the complainant as per section 104 of BSA. So if prosecution failed or defense is weak, the concerned prosecution could not be succeeded. But the key point is that our defense should not be general. If we are taking the special defense, we have to prove it. But again, the key point is that we are not supposed to prove our defense beyond reasonable doubt. We have to create a doubt and we have to work out on the policy of probabilizing defense. So I think that I have specified you the judgment and its beneficial points in your favor in the easier language. See you in the next lecture. Jai Hind, Jai Bharat.